Okay, I'm gonna call this meeting to order at 6:31. And let me get a hold of our other Scott.
Hello?
Hi Scott, it's David.
Hey there.
We found a place.
Excellent.
We're finally inside the building.
Excellent.
So I'm gonna put my phone in the middle of the desks and you can listen in.
That sounds great. Thanks. I'll be on mute. I'll let you know about it.
Okay.
Thank you.
So this meeting is called to order. We are all here one way or the other. You all have received in the email the minutes from our last meeting. I have a couple of changes I'd like to make to those. Of course. Of course. Now that we're sitting down, I can't find them. I was so organized at 5:30.
You got knocked off your game.
I did. I can tell you what they were. In the first paragraph, when Tim O'Brien was talking, one of his statements was talking about the depth and breadth of knowledge required to be on the Board of Finance, and it was recorded as brevity and depth. So I want to change that back to breadth. And then on two other ones, Mark, one of them was yours where,
Yeah, I think there's just some confusion between me and Scott Muller.
Yes.
And so they just flipped
where
those names.
they were attributed to you rather than
Right,
Scott.
exactly.
So we will make those changes.
Yeah.
I was gonna ask, can you guys just introduce yourselves?
Sure.
Oh, yeah. I'm David Lee, I'm the chair.
Marcia Standish.
Steve Mednick.
Brian Eastep. John Peru.
And Mike Fauerbach.
Mark Ginsburg.
Scott Bates.
So I would accept a motion to accept the minutes as amended.
So moved.
Second.
Any discussion? Hearing none, all those in favor?
Aye.
Any opposed? The motion carries. The revised ones are done. Going back to the minutes, we still don't have minutes from our May meeting because the girl who was here taking them has left the employment of the town and they're having a difficulty getting hold of her to get the minutes. And that's still an ongoing issue.
Do we have the video?
The video is there. We really only need to be a recording of the votes, any votes that were taken.
Exactly. So somebody
It's
can
just
just,
minutes,
Oh.
it's not seconds. to get
Exactly.
it done.
There's also software where it'll just give you the transcript off
The
of
AI
the...
should be able to spit it right out for us
Yep.
and then just edit it.
Possible we can get the video from the May meeting?
It's on YouTube.
Yeah,
Then we'll do that. Okay.
it should be there, yeah.
Thank you, I hadn't thought of that. Item number 3 is comments from the public. I see there are none here. So we'll go on to item number 4. There is no correspondence. So we'll go into old business. And Steve, anything from you on the definitions update?
yeah, I have not updated these since we put them in the charter some time ago, since last November, I think it was, in the old commission. But let me explain how they work, and I will, if we approve the concept of putting them in, I'll continue to go through them and make sure that they all apply. I think they do. I think before I put them in last year, they did.
Can I just, one point of order?
Yeah.
I noticed that Brian's on the agenda for a couple of different items. Is there any benefit of modifying the order to,
So you can get out?
yeah?
Yeah. I was
Sure,
thinking the
we
same
could do
thing.
that.
Okay.
Yeah, I'm happy to defer.
Okay. Then we'll go to new business, item number 6. For those of you who don't know, this is Brian Eastep. He's our town's attorney. But I'm sure most all of us do know who he is. So, term limits, pro and con.
Well,
I don't look at it as pro and con. I mean, it's really,
Right or wrong?
no, it's not even that. It's just really undecided and undecided is really what it is, in my viewpoint. There's been no decision by a court in Connecticut, either Superior Court or up through any of the appellate courts, saying that term limits are unconstitutional, unallowed. I know I've read Steve's paper. I've read it for 2 different municipalities that he's working with, that I'm familiar with. Simon B. Canty, which is what he quotes and should, because he was involved in that case, definitely stands for the proposition that you can't recall people because there was no right granted for recall. But the question is, does a municipality have the right through their charter to establish under what circumstances they're going to allow people to run for and maintain office? And I can tell you that there are people that have written and said yes. There are people that have written and said no, as far as that's concerned. There's a report, term limits for municipal officials, from Mary Janicki, who is the Assistant Director of the Office of Legislative Research, who says, well, we think Simons v. Canty applies, but also there's a case, Caulfield versus Noble, in which the Supreme Court upheld a local charter provision that was directly opposite to a state statute. And they said, basically, you have the right to do that. So,
Can I interrupt you?
sure.
So the case that the second one we're talking about, was that people operating under general statutes or special act? Was that municipality special act, or?
It was under the Home Rule Act.
Okay.
Yeah.
So just so they're just the power, the enabling act statutes is what they were operating under?
Yes. Okay. Yes. So, like I said, I don't think there's a right or wrong. It depends what you want to do, depends what the people want to vote for as far as that's concerned. We thought we had a case that might go up, but it didn't go up. It stopped. Best guess is, who knows, as far as it's concerned. Once it gets up into the higher levels of the appellate court, once it gets to the Supreme Court on that. I think the fact that there hasn't been a case on this since 1979, when Simon B. Canty was ruled upon,
Well, I was still in law school. It was 1986.
1986, so.
So, wow.
Really?
Yeah.
Oh, 85.
85. Oh,
85.
okay.
Kind of tells you that it's not become an issue anywhere. People have just accepted, if it exists, or taken it out. So,
How prevalent is it? Like, do we have a sense for how many charters across the state of Connecticut
Steve would
really
probably know
have?
that.
There are not many. I mean, I know Bristol has one. I know that Wilton has one.
Stratford.
Stratford, I think, has
I
one.
count up to, I mean, one of the reasons it might not come up
Yeah,
much is because it doesn't exist.
Yeah,
much, yeah.
and it's not been enforced in most of the communities I'm aware of. I was brought into Bristol, I think I told you the story about what happened in Bristol after I gave my opinion. The mayor lost for following my advice, but because it was a very strident, strong group. And we've talked about this, the difference between Bristol and Stonington. They were both adopted around the same time, but I don't think there was the same vehemence, kind of an ideological vehemence here as there was in Bristol. And Bristol covers all the offices, and not just 2 offices in the city, but there's been no challenge to any of them. So to Brian's point, there is no case law. There's no on-point case law in this area.
And I've looked at it that there's a huge difference between recalling somebody who's already been elected and limiting under what circumstances you can run for an office. And I, again, who knows what would happen if it went up somewhere? Maybe they'd say there isn't a huge difference, you're wrong. Maybe they'll say there is a huge difference, we allow municipalities to make those decisions. You look to the election laws, some of the election laws say municipalities decide everything as far as when the elections are going to be held, and then they say, but maybe not everything. So, it's like everything else. Until there's a case on point specifically, it's a ballgame as to whether they would accept it or not.
A question, on the recall case, was there a provision in the charter that outlined a process for recall? And so the court struck that down, and they said, take that out of your charter?
Because there was no express grant of authority.
Okay.
The way the way the case started, and this is what surprised me about the Stonington case that didn't go anywhere this past year, was somebody went to the town clerk's office to file the petition for a recall. I got a call, or I happened to be in town hall, or some weird thing, I forgot how I got the case, and I got a call from the town clerk to say, what should I do? And from the town attorney, and I said, you should not take it, and force them to go to court. That's what they did. And we prevailed at the Superior Court, then I went right to the Supreme Court and prevailed. So that was a case where they sought the petition, and the town clerk refused to allow them to take the petition out.
And the steps for the petition were outlined
In the charter,
Okay.
correct.
Well, doesn't that, if there was no express right of authority for the recall, and there's no express right of authority to have term limits in the statute, wouldn't they both apply evenly?
So I want to just jump in. I can go to about 3 different legal opinions from Conway and Londrigan that say you don't look for the prohibition. You look for this express authority in the enabling acts. And if you don't see the authority in the acts, you look no further. So, you know, the law firm that's represented this town for many years kind of has a different take on it in written opinions from Jeffrey Londrigan than you're kind of saying the gray area exists, but we've been told black and white that you go look for the authority. If the authority doesn't exist, that it ends right there.
It depends on what you're talking about.
Okay.
And it could be that. I mean, you're talking about a charter revision in your charter,
Right.
not whether you can do it in an ordinance or whether you can do it some other way. And I'd have to know which opinions Jeff gave on those and circumstances. But I mean, the charters are treated differently than your ordinances and your other aspects on that, because it's you deciding how to run your town,
All right.
how to run your city, and you're given more leeway in a charter than you are in ordinances if you don't have the specific. If the state hasn't given you the exclusive right to do something in an ordinance,
Right.
this is different. It's a charter, and that's why the decisions may be different, again, depending upon which ones Jeff wrote, or which ones I might have written, or, you know, somebody else did.
Okay.
But yeah, it's always fact-specific, and it's always what you're looking at, as far as that's concerned.
You know, I think whoever wants term limits has the obligation and has the burden to show us where they're allowed, not that they may be allowed because it's a charter.
Well,
But that's just
Right,
an
right.
opinion of 1 of 7.
response to that would be is, no, the people voted for term limits, so they're currently there.
Right.
So they don't have to show you anything. You have to decide whether you want to modify it and take it back to a vote and decide if they're going to approve that or not. So it's not a question of, you know, whether it's legal or not legal, whether the courts would overturn it or not. It's currently in place. So you as a commission have to decide, do you want to continue that, or do you want to take it out? And those are the
But the
circumstances.
general statutes under the Board of Finance does not list term limits, correct? A provision for term limits? There are some statutes that specifically say you can have term limits, but I believe the Board of Finance does not in the general statute. So if it doesn't have it in the general statute, can you put it into your charter?
There's no statute that authorizes term limits in Connecticut for any office.
Any elected office?
Any elective office.
Any elected
Any
office.
elective
Any
office.
elected office?
So that's the issue. There's no express grant of authority in Connecticut. The question is whether you can imply, out of some other express grant, that we have the authority to do it. And where I would differ from my esteemed colleague is that Simons versus Canty was, to Brian's point, involving truncating a term of office with an elections process. A recall is an election, a reverse election. It's Title IX. It would be covered by Title IX. Elections are covered by Title IX. Likewise, I would argue that the issue of limiting a term is limiting I'm looking at somebody from the Secretary of State's office, he used to be in the Secretary of State's office, would be affecting Title IX rights, the right to run for office, which is controlled by Title IX, not Title VII, which is the Home Rule Act. But they kind of live together. We'll see this a little bit later when we talk about the constables, because you have constables in 9, you have constables in 7, but for our purposes, I think the thing that marries the term limit to Simons versus Canty is the fact that you are involved on the periphery of the elections process. And while the courts allow for you to set the term of office, it could only be the term of office that's specifically, expressly authorized, 2-year term, 4-year term. So you can't do a 6-year term, even though it says you can set the terms of office. The statutes limit you to a choice of a 2-year term or a 4-year term. You can set the month that you want to have the election, but there's only 2 months you could do it, November or May. And so I think that because of the election nexus, I tend to feel, and again, this is my view, as Brian has a view, not been confirmed by any court at this juncture, but I feel pretty comfortable that it would be affirmed by a court that this would be closer to Simons versus Canty. The case I use as an example of where there's no express grant of authority and feel that we can address the issue because it does go to the sustenance or the sustainability of a government, the administration of a government, is a removal, a due process removal process. I will tell you this, I will not encourage you to do it because, again, like the others, the other issues, it's not been addressed by the courts at all. There are a number of communities that have due process removal provisions, some of them, and I've dealt with them around the state, some of which are home rule adopted, but I don't think they did a lot of thought and research, but they're there. And the others are special act. But even the special act removal provisions haven't been sustained by the courts. And so I'd be reluctant, but I can at least make an argument that if you establish a due process requirement for very specified reasons to remove somebody from office, while it does interrupt a term of office that somebody was elected to, it's not because Steve Mednick grew a beard or he got gray and he got old and we just want him out of office. It's because Steve Mednick stole some money or Steve Mednick is now a convicted felon. I'm horrible. I'm self-image of myself here, but there would be very specific reasons and it has to be very, very clear. And around the country, those things have been upheld. Now, every state's different, as Brian will tell you, I will tell you. Home rule is different in almost every state. There's similarities. Some states require express grants of authority. Connecticut's one of them. And so I would distinguish that from these, but I do think that this is more akin to Simons versus Canty than I think like a removal provision would be. I could make an argument that there is a rationale. The Home Rule Act was developed for self-governance, and I think as long as you meet due process standards, it would be hard for me to understand that why a court would not allow the removal of a planning and zoning member who was convicted of taking bribes on the Planning and Zoning Commission rather than letting them go through a full term to finish their term, or for selectmen or a member of the Board of Selectmen or Board of Finance or any other elected body. So I can make that argument administratively, but I don't see it working this way. The other thing that the Home Rule Act is very clear about in the Constitution, actually, in Article 10, is that allows municipalities, it's a delegation. It's simply a delegation of authority from time to time. It gives the local governments the ability to create the government. Then in that act, it says the General Assembly shall from time to time, by general law, determine the maximum terms of office in the various towns, cities, and borough elective offices. And they do, 2 years or 4 years. It doesn't have any, and so it would seem to me that the Constitution, in talking about home rule, is making an argument that the issue of the actual terms, which could be a term limit, would be something that the General Assembly would have under its bailiwick in terms of having the authority. So I think that that's another provision. And where home rule is also clear is they ban the legislature, kind of, from enacting special legislation, although Scott's probably seen it, I've seen it, Brian's probably seen it, anybody's dealt with the legislature. We have modern ways of dealing with special legislation. You get a bill that comes across. Any municipality between 60,000 and 80,000 can do this, but it's not special. It's for any town between 60 and 80, but we know there was a town somewhere in there that got it. But what they do say is that you can't do special legislation, and you know, it's, except they do allow for borrowing power, validating acts, and formation, consolidation, or dissolution issues. And so it's, again, there's no case law, there's no definitive case on it. I'm really sorry that the courts didn't allow the case to go forward in Stonington. I was actually really very hopeful that we would finally get an adjudication. I was sorry I was not going to be part of it because I was conflicted out by representing Stonington, but I was hoping it would go forward. But I feel pretty comfortable that it can be, it would not be validated by the courts. But again, to Brian's point, it's a political judgment that you need to make.
You know, so to, if I could try to characterize it, correct me if I'm wrong with this characterization, the General Assembly has the power to define or talk about term limits, but they don't really specifically address that. So, but they have that, but they haven't opined on this, right? And there's no controlling case law that specifically prohibits these term limits in the context we're talking about in Stonington. And the voters of the town, I forget when the vote was,
2016, I think, or 2016.
It was in the teens somewhere.
voted to do this. It's not like a unicorn. It exists in a couple other towns that we know of. Be interesting to know exactly. You guys seem to know 3 towns or something like that. Hasn't been reversed. So our judgment would be something like, do we affirmatively want to reverse the political action of the vote on this in 2016? Because in our judgment, this is contrary to, you know, what the law is. But we don't really have controlling authority that would empower that kind of decision. Is that a fair characterization?
Everything we push forth, our work product is recommendations
Sure.
for the voters to
Yeah.
approve.
For the Board of Selectmen, they
Yeah,
accept
Yeah,
which I
begin,
think-
right.
But the public would be ultimately reversing a public decision.
Yes, yeah, right,
That's-
that's-
It's for the amendment of the charter. Yeah.
Right, and that's for the amendment.
And then that's a choice that we'll have to think about coming down the stretch, which is if we load up the apple cart with a lot of things, and depending, we haven't gotten these things moving forward lately, so it's interesting.
I have one other, something that came up with the town clerk's office when I was doing research that relates to this. So their concern was, and it may relate somewhat to whether or not someone was under a term limit or not, was 2-4, which is vacancies in elected offices. And in A, it was the unexpired portion of the term, and then it says, and then in case, until the next municipal election. So they had a concern about this. I think Sally originally had a concern about this when those things took effect, and I guess what term they're filling out. You know, if you had to wait to the next election, it could be almost 2 years later, or it could be within a couple of months, and how that applied.
Isn't
And that
it
was a
the
concern.
case when there are many resignations or vacancies, that is filled at the next election, notwithstanding more years to run on a term? Doesn't it generally come up more quickly than that?
Your charter ties it to the municipal town election. I just addressed this issue in another municipality, and what we did, it's going to be a special election. So if there's a vacancy, you need to fill the spot, even if it's a general election, there will be a special election coinciding with the general election. Yours specifies, and I think whoever did it, I think it might be the other Scott, was pointing out differences of a party issue,
Right.
which I think need to be cleaned up. It was a really perspicacious observation, not to suck up to Scott, the other Scott, but the same thing is true here. So what I've done in this other charter in Weston is the next general election. so that you don't, so if something occurs, so long as you have time to get a special election certified. So that's the only limitation, is that you'd have to have whatever occur in time so that candidates can petition to get on the general election ballot and as a special election, so that's the key. But the idea is to try to get it into. Sorry.
Sorry for the interruption.
Oh, we can't share it from that.
Yeah.
But that's a good point. That is a good point. Something should.
Evidently, they're having issues with this, you know, and I think if it's an issue, we need to address it and certainly reply to, you know, whether some term limits also, you know, if they've expired on theirs, can they come in and fill that position, you know? Or is it-
Right.
But the term would be over at the end of the term, so it would be
Yeah,
a
but
natural
it's-
election
say it was a
cycle.
board member who had already done their term limits, and then they appointed them to fill it.
Mr. Chairman,
Are they filling the prior person or theirs?
if it would please the commission, maybe we should just, we got a heavy agenda tonight. Maybe we should go on the record at our next meeting about whether we're going to take this on or not take it on. And, I mean, we could keep, I could just see another 45 minutes or an hour being
Yeah, I have nothing to
sucked
add.
up on term limits and, but I mean, I'm just floating an idea, not making a motion that we push it, but I don't.
And I'll try to do a complete inventory to see if it's more than 3, but I don't think it's going to be, I don't think we're going to reach 7 or 8. I don't think, there might be some small towns, I don't think there's a lot of, none of the big cities have them. And I've been corrected, I've been corrected.
Don't tell Bristol, they're not big.
Well, they're a good sized city. I'm actually going to be working with them on a new venture. So I think very highly of the people of Bristol. It's
Yes.
a remarkable community. Very strong pension program, and yes,
Good.
very, very healthy pension.
And my final will be, I'm neither pro or con.
Right.
I, you know, it's not like I care. I mean, if I lived here, maybe I would, but I don't live in the town of Stonington. But, you know, it's just, we can't tell you, and I think Steve would agree on that, what would happen either side. Whether you left it in and somebody went after it, or you took it out. I mean, if you take it out, it's not questioned.
And ultimately, the voters can say, we agree, or we don't agree, or it could be untouched, or there could be a recommendation. And the recommendation is only a recommendation.
Right.
The final say sits with
Yeah, maybe.
the 18,000 residents who voted up or voted down.
Two questions or comments. So the first, just in terms, one of the things that, you know, running through my head is risk mitigation here, and what would the if it were challenged? So we almost had a case, right? I mean, what would the costs have been to the town of Stonington had this really gone through the full
All the
legal
way to the
process?
Supreme Court.
Yeah.
$25,000 to $50,000, depending upon, you know, if it went directly, if it went to the appellate court first, if the Supreme Court reached down and grabbed it, if the Supreme Court wanted to reach down and grab it, you know, Simon v. Canty, they did. Who knows if they want to on that? I mean, if there's only 3 to 7, we're saying municipalities, the Supreme Court may say,
We'll just leave it alone,
you know, we'll just let it.
We'll just wait till it gets
Wait till
okay.
it comes to us. If it does, or you resolve it. But I mean, and to Steve's point, I know we've had the discussions. I mean, the person who decides to challenge it is basically saying to the people that he's running against or she's running against, I don't care what your charter says, I'm going to run again, and that may or may not go over well depending upon the circumstances. So again, you know, politicians have to decide what they're going to do on that. So.
Right.
In, in the case of the recall, did the court order that the town amend its charter, or did the court just order those things removed from the charter?
No, it was revoked. I mean, it was basically the court knocked down the charter provisions, and so that any community that had one, except for the 5 special act communities, there are 5 special act communities that still have recall in the state of Connecticut because the General Assembly gave them that power. New Haven's one of them.
All right, so that's helpful to understand roughly what this potentially could cost if challenged. And then the second question I had was, if we do, in fact, you know, put it to vote and let the voters decide again, you might need to refresh my memory here. In prior charter revisions, have we given an explanation, or was it simply do you approve of changing, is it just, that-
They've kept it separate, they've kept the questions separate, but the only way we responded were letters either supporting it or not to the paper.
okay, so there's no rationale, 'cause-
Where you might express a rationale, there's two things. One, the reports I tend to write for charter commissions tend to be pretty factual. This was the language, this is the new language. Sometimes we will explain why we went from one to the other. It would seem to me if we were doing this, it would merit some discussion there. Then the second opportunity for it to be highlighted, but then you have to be very careful in this one, and Brian will be the one who signs off on it, is the last act I usually perform for a community when we go to the ballot is I write an explanatory text. And that explanatory text, they're actually much more potent now than they used to be. In the old days, you used to see them at polling places on election day, and then if you voted AB, you got it in your absentee ballot. But today, with posting and putting things on websites, it's a really useful tool that everybody can look at to see what's in the charter revision. And the explanatory text goes through every chapter. It's not a red line. So we have to publish a red line, but in some communities, the red line, it's a ridiculous requirement because it's like reading hieroglyphics. Sometimes the red lines are just so atrociously useless, but you have a statutory requirement to do it. The explanatory text is a section by section, subsection by subsection explication of everything we did. And we have to be careful. We can make an objective comment. Ultimately, the decider on that would be the town attorney. If we said something that it was determined by the commission. Something like that. So there's some explanation.
along
there.
the lines of what Scott was articulating earlier in terms of, here's what we discovered, and these are the facts, and therefore, there's potentially some risk. And
The place for that would be in the report. I'll prepare a transmittal letter for the chair, and you guys can make a judgment. Steve, we need a little bit more. We really want to explain this a little bit more, why we did this as opposed to it was wrong or.
Yeah, I wouldn't want someone to think that, this commission suddenly decided, it's a political motivation, or
Exactly.
we're supporting, person X or person. It's based on the facts and the merit, but to what extent we could convey that.
So is there risk, let's say we to the town overturns this by a charter change? Can someone then sue the town and say you should put that back in? Does the town have to defend it? No.
I had a law professor, Fleming James, who was a Yale law professor, taught at UConn in his dotage. He said, well, of course you can sue, the question is, can you win?
Sure. But going
Yeah.
again to the cost piece, just if we're talking about risk mitigation
I think
and legal
No, I mean,
defense costs.
There's less, if you're just looking at the strict cost aspect of it, there's less likelihood that you'd be successful after a charter revision to say, why did you take that out? Because we, as a law firm representing the town, would say, the people took it out. Sorry. It's not like you took out something that you're required to have.
Yeah.
There are certain things you're required to have. Like if you eliminated your executive branch, that would be a problem.
That's a mandatory provision.
Right, so if there are those circumstances, but under these circumstances, no, it was a decision that went in, decision that came out, it happens. The next commission might decide to put it back in again, you never know. These kind of things, and they really, if push comes to shove, you're affecting such a small group ultimately on this. You must know, getting people to run for office is difficult to begin with, and then the circumstances, so in the relative scale of your size of your town and the overall people versus who this might affect. That doesn't mean someone couldn't sue, and someone did sue. But no, I think when you remove something like that, absent it being something you're required by law to have.
There was a great chart that you provided, I think, that had the percentage of people who voted in different referenda over the last many years. Thank you.
That was great.
And I wonder, I'll take a look at it, in the 2016 referenda on this question, what the percentage of vote was, because my memory, which, and it's all subjective, was that people are very exercised on this issue. It probably had a big turnout, and so that, in my mind, is an interesting point. If it's like 20% of the people voted on this question, whereas what kind of turnout do we usually expect for a charter revision?
Yeah, just for a point of, I'm pretty sure it was a 2015 municipal.
Well,
It's on here.
Yeah, what's some of the irony here too, though, is so, back then, or prior to those charter revisions, we had Board of Finance members who were on for 6-year terms.
Yes.
Which it's interesting to see.
Yeah, right.
And we switched that to 4.
Exactly.
Now we're in compliance
Yeah.
on that matter. And then we introduced a different topic, which potentially puts us out of it.
Well, the other thing too that was complicated was how do you fit the terms in when someone's term expired? So when you take that out, you now have to figure out how that's gonna work
Half
with the
half or
people.
more, right, has been the standard.
Yeah, so you have to change that as well. It's not just,
So I'm showing November 3rd, 2015 for the Board of Ed and the Board of Finance. Both had term limits.
Yeah, that was the year I got elected, and I was the first year under the new terms with Board of Finance.
So,
Seems like yesterday, Mike.
I know.
I mean, are we going to decide tonight with an idea, or do we roll it around in our noggins for another month? And
Personally, I think we, based on what we've heard this evening,
right.
we all ruminate on it and make the decision next month.
does Scott have any thoughts?
Scott, do you have
Motion
any
to that?
thoughts?
I'm fine with that. You want a motion to that effect, or you want to just push it?
David, you just asked me a question.
I did. Do you have any opinions on what we've been talking about, whether we make a decision now or push it till next month?
I think pushing it to next month is, I would do that. I must say I agree with Scott. If the voters have wanted this in the past, I don't think it's up to us to decide that they can't do it. The laws aren't clear. If they want to try, we can do it. If someone wants to ultimately settle a case or not defend it down the road, that decision could be made too by the selectmen.
I would entertain a motion then to postpone it till next month to make the decision.
So moved.
Any seconds?
Second.
To Marshall, second. Any discussion? All in favor?
Aye.
Any opposed? Motion carries. We will decide this next month.
Thank you for the presentations.
Yes.
It's great.
Thank you.
Ryan, did Steve mention the possibility of discussing constables with
He
you?
did.
I would love to hear your opinion.
Well, you can have them, and you can have them under different circumstances. Either your charter currently has them, you can have them, and also, and this one there is an actual opinion by Tom Longren that I pulled out, that I could find. You know, I'm sure you've talked about it, but there's 2 types of constables. There's the ones that you have in your charter, and there's ones you can create by ordinance. The ones that you have in your charter are basically versions of a marshal. They can serve process, they can do things like that. They can't do anything on the criminal law end at all. If you create an ordinance, then your selectmen can appoint constables under that provisions, which they can then do those other things, but they can also be involved in criminal matters and those circumstances. I think that the second version is probably, if you want to talk about cost-benefit analysis for the town, the odds of you getting sued are a lot greater if you have a group of untrained people getting involved in the criminal process in those circumstances, because they'd be allowed to, you know, do things that puts them into a law enforcement status, and it'd be people who theoretically are being appointed with no training, no background, no circumstances under that, where, you know, you're in that circumstance. So I guess I would put my thumb on the scale that way. I'm not sure you entirely would want to go that route. Or the second question is, do you need constables? I think a lot of communities have eliminated them over time because you really don't need them. There isn't a requirement that you have them. There is the ability to have them if you want to, but there's not a requirement that you have them. I did notice, because I looked at it, hadn't dealt with it, the issue really, I mean, you've got 4 Republicans and 4 Democrats that get elected as constables. I don't know what the circumstances are, how they get elected, or what, I mean, I know they get elected, but I mean, how they get on the ballot or anything else like that. I don't know how active they are, or how active they aren't, as far as that's concerned. I mean, as a law firm, we don't use any constables to serve anything. We use state marshals, because they can go, you know, anywhere in the state once they do something locally. You know how state marshals work, they get appointed by county, and let's say, for example, you want to sue 4 or 5 different people, as long as they start their service in the county that they're appointed as marshals, then they can go throughout the state and complete the service under those circumstances. So, again, I think, it seems like constables are probably from a bygone age, and that's probably why a lot of them don't exist. But I don't know what specific questions you have.
So Scott Muller was on the phone, he dug into this, and he turned up some statutory language that the number is 7.
Mark did it.
I
No,
thought-
Scott raised the issue about the number. I prepared a very brief memo
Yeah.
on some of these issues. And other than the town of Groton, which is permitted to have 14.
Right.
And there was some explanation for the reason for that. But there was also some suggestion, because it's in our charter that we have 8, that would go beyond. And that was the question for Steve, is the fact that our charter specifies 8, does that non-compliance with that 7 obviate that?
It's not clear, because the statute 9-200 says each town shall elect at its regular municipal election unless otherwise provided by law, not by charter, by law. Now, charters can be included in law, but I've seen provisions that are very specific unless otherwise set forth by law, the charter ordinances or something like that. So I don't know the definitive answer on that.
So we may be in non-compliance.
We
with
could be
8.
in non-compliance. Now, I don't know why they would be mandating
The number.
the number not more than 7, because then you have an interesting political question of why do you need a majority of any party? And then I guess the other issue is minority party representation statutes, as Scott has pointed out, really don't anticipate. It really is a cap on a majority party. It's not there to be protective of both political parties.
David, maybe
Yeah.
maybe I can add a little bit to this to clarify. The first question is whether, assuming we want constables who are elected at all, an issue on which I expressed no view. The first question is whether we can have 8. The statute says 7 unless otherwise expressly provided by law. I've actually had to look at this for reasons unrelated to this commission. The word law in that context means statute. It does not mean ordinance or special act. When the code includes ordinance or special act, it actually says that.
Correct.
Law generally means the statute. So I think kind of there's a strong, in my own view, is overwhelming argument that law means statute, and we're limited to 7. So that's issue 1. Then if we want them at all, then we have the issue of the way it's currently written. It provides an equal number for each party. That's problematic, both because it requires someone to be a member of a party to be as constable. 2, it assumes 2 parties. And 3, it's contrary to the minority representation statute, which we actually incorporated into the charter. I don't remember what the number is, but I think if the number is 7, as I think it's required to be, then I think it's a maximum of, let's look at the stat, I don't know the word it's right, I think it's probably 4, a maximum of 4 from one party.
I believe it's 4. Scott, I tend to agree with you on the law aspect unless it's otherwise defined, but because as I indicated, it usually will reference special act or charter if they want it to mean that, so I would agree with you on that. But the issue, let me just say, I agree with everything Brian referenced. My experience with this is a number of communities have moved away from constables. Constables historically were the police before there was police, basically. If you go back to colonial times, the constable was a pretty important figure in most of the small towns. What I have found in different communities, we've eliminated them in some communities because they've just said, what do we need them for? Most constables do some work for probate judges. The probate judges use constables within their district, but would have to be within the municipality that they're from or that they're serving. And the principal decision has been a political decision, not a legal decision, because most of my communities have concluded that you don't really need them There's very little function served by them. But I have found that in one of my communities, most of the constables said, I really don't do much. And two of them said, no, I make a lot of money. And because they have a relationship with a law firm, a relationship with the probate judge, or whoever it may be. And so they've made a judgment. These two guys are making money, so let's bring it down from 7 to 3. So the two guys can continue to make money. And it's a political judgment. And others have looked at it. It might have even been stated, as we talked about it in an earlier phase here, I'm trying to remember, where somebody said it tends to be a feeder for bringing people into the political ticket, to get people into the Democratic or Republican ticket, or if you're a petitioning party or something like that.
Socialize their name.
To socialize their name and get them involved. Look, is that a good public policy reason? I don't know, but that may be a reason why some people do that. I think we have to address the issue of the number, and we'd have to correct it at the next election cycle, is what we have to do. And if we were going to do that. But then the broader question is whether you feel they're needed at all.
So, it's not part of our original charge, right? This wasn't. But I think based upon the research that we've gotten from Scott and from Mark and from two councils that are here, I think we're compelled to add it to our to-do list, just based upon this preliminary research. Now, that's not taking an issue whether they stay or go, but I think that there's language there I find that is incompatible with the statute. However, well,
Just a quick research, 9-185 says, unless otherwise provided by special act or charters, blank, 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 constables, subject to the provisions of section, et cetera. So the question is, looking at 185, because 9-200 refers you back to 185. 185 may be saying that if you have a special act or charter, it's contrary to what the statute is, that you can either elect them or appoint them. So I'm not sure if that was looked at in the background on that, which might be how they got around having 8 instead of having 7 because you have a charter.
But that's the issue of election versus appointed, and I don't think it addresses the number in 9-185.
Well, I think that,
Still-
but the 7 relates to the election.
But I also think that the issue here, and I think from Scott, was that it was from the 2 political parties. And what about all the other voters that aren't? And I think that's a bigger issue. If and I don't know if you can do anything about
So I
that.
think the
If you keep
last-
the constables in, you have to do it with the 2 parties. If you take them out, it's,
But although the last election, Scott Muller, I think the Forward Party ran a slate of constables that were on the ballot, right?
It did. And you can eliminate the problem with the parties by simply saying no more than 4 can be from a single party.
See, that's the fix.
That's the fix.
That's, yeah.
And then the question is that political question, do you want constables?
Right.
And perhaps before we act on it, we check in with heads of the various parties and see how valuable they think that is.
I agree with that.
Or a probate judge at Lehman. She actually
Oh, yeah,
is.
that's a good
Yeah,
point.
yeah, yeah. I mean, I wrote
If-
that down and called Beth.
If she actually uses it.
Yeah, right.
And if that's a practical matter.
I can share just an anecdote. I might have shared this last time, but it was 2 in the morning where I was, so I might have been telling tales. But when I was Democratic Party chair, I used the constable position to recruit new people into the political process. And then their question was, what do we do? And I looked and I said, I don't really know. I went through statute, and there was something about like public health or something somewhere. But that's neither here nor there. The point was they weren't activated. Like they're not making money. They don't get paid.
And it doesn't cost the town.
It doesn't cost the town anything. And then this goes to
Well,
John.
but they only get paid, though,
By
if they're
the-
serving tax warrants or they're serving things, which they can
Sure.
do within the town only. And
Yeah.
that's the other aspect.
I see.
So,
Theoretically, they could do that. I don't believe that they are, but I could be mistaken.
Well, I know 4 of them, and the answer is no.
Right, there you
Well,
go.
but, theoretically, if I was a constable and you said, could you go serve this, I'd be like, I'm out of town.
Yeah.
Find somebody else. I would run scared.
And John raised something that's really interesting, because you mentioned that, okay, look, if this thing's out of whack with the statute, then we have to address it, or we should. Because that's like an affirmative, but it seems like it may not be. Then that goes to the overall question, Mr. Chair, and I don't know, we can do whatever we want to do. Philosophically, are we going to try to keep to the narrow mandate that was given to us? And then there's another political type question, which is what do we think can actually move forward? And this is for a conversation next month.
Yep.
But what do we think can really move forward? What might attract something that would knock it down?
We don't want any poison pills
That's
in
my
our
point.
recommendation.
Right.
I think on that, we can still, I would think the selectmen may entertain like they did in the past to separate the questions. And I think if there is an area that's important, then people still have an opportunity to devote a section down, but still let the rest of it go. you know?
Interesting.
And then addressing your narrow define, they also asked us to perform a comprehensive review.
So that opens the door
And
to
suddenly now,
everything.
we go from this to this.
Yes, right.
Yeah, I'm
Which,
sorry.
which in the last charter, the very first charter commission 3 years ago, we were given the same charge, but then it was narrowed to a few specific items. That hasn't been the case this time around.
Yeah, there were some specific things that needed to be done before the following municipal election, and that's why we ended up narrowing and ended up having the second one convened. That was a very different circumstance. Let me make one last point. This underscores something Brian talked about a few moments ago. In the community where we ended up keeping them, I think we reduced the number so that the guys who want to make money can continue to make money. But we also put a provision in the charter that the constables need to be trained, because the concern was these people are going on private property and serving people. Is there a potential liability question? So we did require that the Corporation Council develop some kind of training program for people who are going to be serving those functions for the municipality, on behalf of the municipality. And that
Do
would be
they have authority to go on property
what they serving.
when you're serving a picture? I know that certain, like the building official does, but there's certain departments that do not have that authority.
I think marshals can go on property.
I think if they can serve
They can go on
tax
property.
warrants and civil
Yeah.
process, I think they can go on.
They can go on
private
property.
They probably, I mean, they can't go in private property, they can't go around, but I think they can walk to the front door.
But if they were injured or somebody else was injured, who's liable at that point? So if we are gonna keep them, we might consider a provision like that where there'd be some training element.
So one thing I just want to clarify, just give, I'm working on the assumption that we are going to have separate questions on the ballot. I mean, I think we've got a precedent now for doing such, so is everyone else doing
We
the
don't
same?
We
You don't do the
that.
questions,
We don't do that.
the Board of Selectmen will
Well,
develop the
all right,
questions.
so we're going to strongly
Strongly
suggest
recommend.
Yeah.
that, right, because, yeah, otherwise, I think we could get caught up on, is one question going to sink all the rest? I don't think we want to
Oh,
go
yeah,
down that.
no, yes, and that's a really good point to think about, but until we know what we're doing, we can't even suggest what those separate questions may be. And you also don't want to have 8 or 9 questions. You want to, I've never had more than 3 or 4 max in any of my charters. I don't think I've ever gone beyond that in the charter, but it's, I've had communities where they wanted to do 9 and we shot it down, but it gets more
There
difficult.
were a healthy number last, how many were there in the last vote?
I think people have the bandwidth for 9, but that's just me.
Yeah, we have to see what the questions are.
You are
what the issues
unusual,
are.
John.
No, I mean, I've heard from the communities, like, get rid of the constables.
Yeah.
It's stupid, they don't like the visual pollution, they don't,
The
it's
sign,
like,
the
yeah,
sign,
they don't like
the
the
electric.
sign.
Yeah, right.
It's an uncontested thing, and then the people don't do anything. But then the
Because
question,
each party puts up 4,
right,
And
and so all 4 are elected.
And there may be more than 2 parties. you know, so.
and there's some serious people that really feel like the two-party system needs a third,
Right.
you know, needs,
But interestingly, some of the feedback I got from some of the, on the political side was that there was no shortage of people that cared to be presented as constables. Because I would have thought that there was a real difficulty in getting people to stand up and put their hands
Now,
up.
we had fights between people wanting to be on the ballot,
Even though they weren't doing
even
it.
though they weren't, yes.
There's nothing,
Yeah.
yeah, your name's on the ballot.
Right. Okay. So that
So-
off and,
Push it to next month, I guess?
Yeah.
We need a motion, or we're just a consensus?
We'll just push it to next month.
Okay, good. Thank you.
No dinner.
Can I just want to add one question? Scott, that was you talking. Am I correct in understanding that there are actually significant numbers of people who want to be constables?
yeah.
At least in my limited experience, that was the case. I was pushing older folk off and trying to get new people in, and a couple of them got bent out of shape over a position that did not, But a couple of those people have moved on to be on the Board of Education, and I forget what other things they've gone on to do, so.
Well, the other thing, we can consider term limits for that.
Yeah, there you go.
Term limits for constables.
Now, it's
Yeah,
interesting
eliminate
you
for
have that
everything else.
experience.
Yeah.
In the last election, both parties really had to push people
To find,
to consider
Yeah, it may
being
be
a
different
constable.
now.
Yeah,
My
it
experience
is.
was
Yeah,
like.
it was an afterthought at the
I
last.
mean, just to give you an idea, I had
Yeah.
to push my daughter to be a constable,
That's cool.
because it was one of those things that, okay, we have 3 people, we need a 4th.
Right.
And so my wife and I sat her down and said, you really need to do this.
Oh, my
So a little
goodness.
bit of parental pressure.
but is our sense if the feedback comes back from the political side that, hey, this is more of a struggle, then that kind of pushes us to the abolish side, and then we resolve the number and
Yeah.
everything else.
Before our next meeting, I will have him met both with the DTC and the RCC
Okay.
chairs to sit down and talk with them about this.
And how about the other party?
Yeah,
Sure.
Scott Muller.
Yeah.
Yeah, look, the only way we can do this is no one party, the number's going to end up being 7, I think, I'm listening to the comment back and forth, and no one party can have more than 4. After that, it is what it is.
But do
we
you
have-
wind up, there's 2 questions here. If you eliminate you put a question out there to eliminate the constables or change the number of constables, or can you make them,
You can't-
you can't.
You can't go either or. You've got to
So
make
we
a
either have
decision.
to,
One.
so.
You have
so
to decide.
If you
which
go
one
with
goes.
eliminating them and that doesn't go through, then they're gonna have 8.
It's not a, yeah,
Yeah.
it's not a, yeah, that's right.
Can this go to, did you say they could be appointed? Did you just mention appointment?
By ordinance, you can give the power to the first selectman to appoint constables.
I thought those were only
Just
for
the
the
first
special
one.
constables with different authorities.
Well, they have different authority, but they
Yeah.
also, I think they also have the original authorities as well. They have more authority. So those are the circumstances.
So how would we would take it out as being part of the charter as elected, and we would recommend that it be an
No,
ordinance?
the first selectman shall have the authority to
If we
appoint.
thought there was value in it.
If there was
But,
value.
Yeah, I think, I'm not sure
And
we
then
want
we
to go
could,
there.
then with the ordinance, they could set the number and.
My experience on things like this is, I told you part of it, but in general, more and more we're eliminating
Yeah.
offices.
Keep it simple.
You did it here a couple of years ago, the town clerk. You eliminated them as an elected official. Other communities are eliminating treasurers and town clerks and moving them to appointed positions. And a lot of it is the change in the civic culture. It's harder and harder to find people to run for these under-ticket positions. And so that tends to be a trend. And I know we've eliminated constables in a couple of communities. So,
Look forward to hearing what the chairs.
yeah, that's
Me too.
serious.
I've started the conversation with one of them, and it's kind of gone back and forth.
Interesting.
So we'll get a definitive statement between now and next week.
I'll check with them.
But also worth asking the first selectman, or potentially asking the first selectman if he, or in this case, they, want the ability to appoint as opposed to elect.
The other aspect to that is the state law limits terms for 2 years for special constables being appointed. So if you do that, they can only be appointed for 2 years, have to be reappointed, probably with the understanding that you're going to have new executive people in, and they don't want to have the constant, aspect on it. But, again, that's your call.
Well, Brian, thank you so much.
You're welcome.
Yeah, that was great.
Hope I
Thank
was
you.
of assistance.
Oh, yeah.
See you soon.
Talk to you later, Steve.
I will call you.
Steve and I have argued some of these things for a while. And knowing him, that's why I got him appointed to be here, so he wouldn't be able to litigate. No.
Better inside the tent than out.
Yeah.
Yeah.
See you later.
All right,
Thank you.
Thank you.
Yeah.
Move the tables farther down.
We can go back to this table, no, whatever. I thought we had solved our problem here, too, the sun is going down. Okay.
Shall we go back to definitions?
Yeah. So what I was suggesting is, what I've tried to do in all these charters I've worked on, I don't think there's any charter I've worked on now that doesn't have definitions, is I have put a definition section usually in the front of the charter. Again, it makes it easier, more accessible for the public to see what the common terms are. Most of these are pretty standard, and I did do the research at the time. I'll go back and look at my notes to make sure that was the case. The biggest one that I want to bring to your attention is the issue of public notice and meeting notice. What I've tried to do is, a lot of charters, and it's not so much true here, although there were different standards, have different standards on notice, and you go through a charter, and it's very, very confusing. And one of the things I've tried to do in all my charters is to eliminate newspaper notice as a requirement. And so the public notice decision allows for newspaper notice and requires it if it's a state requirement, but it is no longer a charter requirement. So you can make a judgment that you're going to put something in the newspaper, but for the most part, I think that's the most significant thing of all the definitions that I write. It's the one significant one that's has impact on the charter. And the other element of that is it's in one place. So if you see the term public notice, you go back and look and see what that means. And so that's the concept of it.
So just on that point, I think I forwarded you some of that language. I found some of the other, I don't know if it made it your way or not, but I mean, that might be something, where it gets away from paper, newspapers, and it seems like a couple of towns that have modernized their charters in the last year or two.
Do you have
gone
that,
with
or-
some generic language.
I do, I'll send it to you.
Okay.
Yeah.
I might have written some of them, but the.
Yeah, you may have, yeah.
Because that's been something I've been working on. In fact, I'm working right now with one of my COGs on dealing at the state level with addressing the issue of mandatory newspaper notice requirements. And one of the big problems, we had it a little bit here, but you actually have two newspapers that you can kind of go to, and one of them's, neither of them are Hearst, I don't think.
No.
So you're lucky.
Right.
But if you're in a Hearst community, the publication of the charter could be $15,000, which is absurd. Weston, the town of Weston, used to have a local newspaper they don't anymore. And so I told my COG, which happens to cover Weston, which has to be doing their charter right now, that one of the things they should look at is what are the circulation requirements, what are the circulation numbers for newspapers in Weston. And you'll find that the New York Times and the Wall Street Journal are the high circulation newspapers in Fairfield County.
Yeah.
Not the Stamford Advocate, not the Norwalk Hour, it's the New York Times and the Wall Street Journal. Is that what the legislature really wants us to do? Do we publish there? Because I think we're actually going to publish in Norwalk, and you can't buy the Norwalk newspaper in Weston, but it's in the library. And it's the closest big city, Danbury's a little further away, to Weston. It's absurd. But the problem is the new president of the Senate is from Norwalk, and Hearst newspapers are based in Norwalk, so in the state of Connecticut. So fat chance getting that change, but that's the big change that we have here. And I'll take a look at the language that you provided, but that is it. I will go through it again to make sure there's updates. I have modified my public notice requirements. I found one of them was very murky, but I've cleaned them up, and I will just compare what I have here to what I've modernized with.
These are the ones that I went through about definitions. There's one other words that may need to be defined.
Oh, good.
Put
Thank you.
those
Yeah,
together.
and we'll update them. And again, until everything is finalized, this is not final. Yeah, so.
Right. And one of the things when I was doing about the elections, another word that came up was inhabitant, which I thought was an unusual word to put in inhabitant.
Is that a resident or
Well,
elector?
The definition
Elector,
is in
yes.
here.
Yeah,
I have
I
the definition for inhabitant, but it was the first time that that had kind of come up about public, it says, in municipal and local statutes, inhabitant is often used to mean a person living within the boundaries of a town or city. So, it says whether a tenant, owner, or occupant, so doesn't really say whether that's an elected one or not, but I thought it was kind of an interesting.
And I'll go through this, but just looking at it quickly, you have a separate definition for commission, or, in my general views, I tend to use board or commission interchangeably, because they tend to be the same thing, so that an advisory or study commission could fall within that category. And so I'll take a look at these things and make sure that I haven't missed anything. If I see moderator, something, home rule ordinance, we don't really
Something
need, a
that
home rule ordinance is not something you really would do with a charter. That's kind of an alternative to a charter, but I'll take a look and see how it's used in the charter.
So, kind of jumping around a little bit, but I just wanted to pick up a little bit on the public notice requirements. So, I was just trying to looking at boards and commissions, which is another agenda item. And I got into the planning and zoning ordinance, and there's public newspaper requirements in our ordinance right now that for somebody to, before a vacancy is filled on planning and zoning, we have to do newspaper work. We have to do newspaper work. It's in our ordinance, and it's not in our charter. I mean, we've got this global discussion about what we put in the charter, what we don't, but if we got some ordinances that probably need to be cleaned up because they're mandating things that are going against what we're trying to do. Yeah.
Well, then they would be invalid if that's the case. And one of the things that, let's take a look at the appointment authority here, because I don't remember seeing that.
So the planning and zoning ordinance was modified to put in limits, but also there's a public notice requirement before the Board of Selectmen can appoint, which is just, and I probably understand why it was done at the time, but it opens up this whole other discussion about our ordinances being maybe much worse condition than our charter is.
I think there's feedback we probably need to give to the selectmen.
Absolutely.
As a result of this process, we've just, we
not
recommend that there's another group.
There's another group that scrubs the ordinances.
Yeah, there's work to be done.
Well, I have actually put into charters, this is not a Steve Mendick work, back to work provision. 10 or 20 years ago, I'd say it is, but at this stage of my life, maybe not. But we do mandate in some of our charters a review of ordinances post-charter revision, because I've had a lot of communities that have just been really bad. The biggest one is Hartford.
I'd be in favor of that
Yeah.
without even thinking about it.
And you actually should look at it, the town attorney should look at the actions of the General Assembly every year to see if there's anything that is adopted by the Assembly that would change a requirement in your ordinances.
Right.
You can't change your charter. You should note that something in your charter may be out of whack. Again, express grants of authority, the express grant of authority has been taken away. It very rarely happens. But particularly with the ordinances, and particularly in planning and zoning, there are a lot of changes there. It is entirely possible that you could pass an ordinance. It's not inconsistent. All the charter says is you appoint, the Board of Selectmen appoint. If there's an ordinance that say they have to appoint following a public notice, a newspaper notice, I don't think you should have newspaper notice for anything, but that's neither here nor there. But they could probably do that because the definition in the charter says may include newspaper notice. So if you decide by ordinance you want to have a newspaper notice, or the town clerk decides, I'm doing newspaper notice on this because I think it's important enough to put in a newspaper that 3 people are going to read, whatever the reality is with the 2 newspapers you've got, they can do it. It doesn't stop them from putting in the newspaper. It just simply allows you to post things in a modern way.
One of the problems with newspapers, the Sun doesn't publish Monday and Tuesday. they don't publish on Saturday or whatever, so there's days they don't even publish, so you would have no reliability except the day present. And at some point, we may not even have newspapers, and they seem to be,
Yeah, I think we should move away from it in the charter.
So-
Have you seen the day paper on Monday?
Nothing, yeah.
I mean, it's,
And that's when it's folded.
Yeah, right.
So, Mr. Chairman, you said vote needed on this. I would make a motion that we instruct Attorney Mednick to continue developing definitions for our charter.
I'll try to do an update, a more comprehensive update, but it won't be, until we're done, we don't know, I'll go through all of your comments, but until we're done, we don't know what they're gonna be, but at some point, we may preliminarily approve it, subject to change as we go through the process. But I will take a look and make sure by the next meeting we have an update of what's in the document right now. And I'm making a note about ordinance revisions being a provision that we should think about putting in here.
So we have a motion on the table. Do I hear a second?
second.
Second, yeah. And to send it in advance if possible, so we can.
Oh, yeah.
Yeah, sure.
All in favor?
Aye.
Any opposed? Motion carries. So we've already talked about constables, so we don't need to do that again. Marcia, you had something on referendum.
I do.
Before we get to that, if I can, the memo I sent around had an issue with respect to what we say in there about registrars, which I believe is inconsistent with the statute, and a proposed additional language with respect to the minority representation statute. We don't need to do it now, but I want to make sure they're not lost.
What I'll do, this is Steve Mednick speaking, this commission's gonna have my full-time attention as my other two charters are winding down. I will, when I'm doing the definitions, I'll go through the document and take a look at all of our minutes and try to update the document within the balloon section to say these are sections we're looking at. And so I'll add those comments, Scott, to all of the comments that are in your memo to that, so that hopefully by the next meeting I'll have a markup that shows what we're working on at the present time.
Great.
Right? And I apologize, I've been a little errant, but I'll make sure we take care of that.
Okay, moving on, Marcia.
Okay, I was asked to review about referendums, especially the one with the 20 voters in the town. So I did an AI search and basically came up with chartered municipalities and non-chartered municipalities. And from that, I went through and provided all of the general statutes that sort of related to the actions.
You got it too. So,
And following that, so all the rest, and then what came up on one of them, as I said, was inhabitant and how that definition kind of works into it. And probably add to a definition. And then I provided a few of the charters. I did Groton and Glastonbury. Some of those have RTMs, and but on how they established it by a percentage of the voters. So that was sort of providing some language.
I need some help. I forgot what the question was.
Oh, it was based upon, in our charter, 20 people can call a town meeting or put a petition into the town clerk
Right.
to look at an issue.
And was that number too low?
Yes.
Okay, thank you.
Right.
I thought I wanted to be certain.
And then I
Yeah.
went to the town clerk's office, and they gave me a history of all of our referendums. Most of them were budgetary referendums, to kind of show how many people actually came out and voted and what the purpose of the referendums were for. And then also went to the Board of Finance. They just have meetings and referendums. They're kind of put together. So most of those would be setting the mill rate, things along that line, and what it's costing to do the referendum. So we'd have a little bit of idea on that aspect of it, so.
Am I-
So, is it,
Right.
you know, it's appeared that the data that you found suggests even at 20, it's not being abused. There aren't that many of these, and they're not that expensive.
But there were 20 town meetings last year, right?
I believe so.
think
Yeah, but
I
most
think
of it were not on the 20, not petitioned by 20 voters.
Right,
Most of these were brought on by the selectmen,
I see.
And they self-initiated and not,
right, or for a major purpose, you know, it was, what was it, ordinance.
Yeah, I was a little surprised, to be
redevelopments.
honest. I thought it would have been utilized more than it had been. That having been said, my gut still tells me that 20, and based on some of the data you were circulating as well, it seems like 20 is a particularly low bar, and that, if you're thinking about, I mean, some of them do as a percentage of eligible voters, or, it's 50 or 500 even, so, that 20 does, it hasn't been abused to date, but doesn't mean it couldn't be abused going forward, I guess.
But, I mean, what's the, like, if there's a town meeting and you need signatures to push the town meeting vote to a referendum, what is that number? That's a percentage, is that? It's a much higher threshold.
Well, there's 200, there's one where it's 200, but this one was a special, this was the 20.
Right. And, but I mean, I remember the tax abatement for Cogswell Street passed a town meeting, and people immediately petitioned to put it to a townwide vote. And I think that, what was it, a couple hundred?
It is, I think it
It's
is
like
like 200,
200,
yeah, I think it
it
is
is 200.
So, I mean,
But
there's,
but the other one refers to, the 20 said, when I did the AI, non-chartered municipalities. So we are a chartered municipality.
We are a chartered, right.
So I wonder if the 20 is a moot point.
oh,
what is the section in our charter that addresses that?
Yeah, I'm looking at that right now, I'm sure.
I'm just gonna find it back and hopefully get back in. Oh, the door's open.
Not cloudy.
The power of initiative and the power to overrule.
Yeah, the section was, put that in here too.
3.1.
3.5, 3.3, yeah, 3.4, 3.5.
$200, page 8.
Right, I was pretty sure it was 200, but again, when I did the search on it, it mentioned that section 7-199 related to non-chartered municipalities, and it had a referendum can be brought up to a special town meeting, 20 individual.
I think it's at 20, yeah, so.
And we recognize 20 too.
Right, but that's, I mean, for someone to be able to call, I don't know, if you had a special interest group, yeah, they could, I mean, you get 20 people to force a town meeting, and you know, those generally aren't very well attended, you know, they're not saying special interest people would go to that town meeting, pass whatever it is they wanted to pass, wouldn't be that hard to do.
Right.
Then you've got to have someone who comes in and tries to overrule that, then they need 200 votes.
Right.
Yeah,
But it
yeah,
says
yeah.
all chartered municipalities that have adopted a referendum provision in their charter allow a public petition for a referendum, and I think that's where you could put the percentage and stuff and get away from the 20.
Yeah.
That's kind of what my reading of this was, so.
Right, yeah, I would read that way too,
So this is section 3.4B2, we're concerned about the 20.
yeah, that's, yeah, ordinance shall be signed again. Or no, that's 20.
Not that it's, again, not that it's a major problem, but because we have a charter, we could eliminate the 20 and put
Put
a
a percentage
percentage
in
or
that's
whatever.
more-
Yeah, I think, but that would be it. I think, Steve, if you can.
Yeah, I'll take a look at that. Yeah, I'll take a look at other municipalities. But again, these indelible ink, indelible pen.
Yeah, that sort of stuff is a
requirements
little
are
funny too.
absurd.
I mean, it's so out,
Yeah.
old to begin
Yeah.
with.
I'll take a look. But keep in mind that these tend to be these have the potential to be controversial sections. One of the things we just eliminated in Weston, although it's turned out not to be as bad as we thought, is they have a referendum, but they also have a requirement for a post-budget town meeting. And it's been abused in that community because a small group can convene it, a small group shows up,
Yeah, so
and
it's
they knock things out.
Yeah.
So, and so the town has decided to eliminate, let's go right to referendum. Why mess around and let a small group distort the
And
document?
the fact that it hasn't happened to date, I mean, I think the times are different now too, with social media. I mean, it wouldn't be that hard to get 20 people to pretty quickly rally on a particular topic on the Stonington Forum, and, you know, and then we're, you know, then you've got to hire, then you've got to do, you know, 200 to try to revert. It just seems like the numbers are out of balance. So I'd be in favor of, yeah, some more benchmarking here on what a reasonable percentage.
And that's an interesting question. Should they be the same?
Yeah, potentially could just be the same.
Same.
200 to put it on and 200 to overrule it.
Yeah, I'm in favor of raising it. I just don't know what the number is.
And Michael, not to, because the one comment we heard when someone spoke of that from the public, how important the initiative opportunity was and not.
Right.
And I fully agree. I think it should stay. It's
Right.
just, let's make it a reasonable, you know, threshold that needs to be
What
achieved.
I'll try to do is give you a comparative analysis of the other municipalities that are similar size and similar structures to get an idea.
Do they do it on the basis of voters, or do they do it on the basis of residents, or
So,
how do they?
well, it depends on what the referendum is. If you have property rights to be able to vote on certain things,
Right, with the two
you don't
votes.
have to be an elector. You generally have an elector requirement to participate. In the referendum, in a town meeting, referendum, you have to be an elector. So in a town meeting, you can have people's property rights who get to vote. So,
2,000
yeah,
value.
or whatever it
Which
may
is
be,
not
yeah,
much,
it's not that much. So,
Okay,
I'll
moving,
take a look at that.
item E, Marcia, did you have a chance to talk to any department heads?
Just the one that I mentioned about the town clerk's office with the voting. That was the unexpired portion of the term, either at the next municipal election. They wanted to take a look at that, the
Okay.
town clerk's office, the 2-4, so if somebody wants to take that on.
I'll give Michelle a call. So we've covered on new business A and B already. Municipal asset disposal in surrounding towns.
Yep, happy to share what I've learned in this space. I don't have any handouts, but certainly give you guys some, send some things around if you want more after we talk about it. But so this is section 3.3, special town, 3-3, special town meetings, page 6. And under, that section starts with special town meetings shall be called by the Board of Selectmen for consideration of the following. And item 4 is the sale or disposition of any town-owned real property and the sale or disposition of any town-owned personal property whose value exceeds $5,000. And this was one of the matters that the selectmen did ask us to take a closer look at. So did do some research on this topic. First thing, somewhat surprised to learn is there are some general state statutes that govern some of this. What's it, section 7-163E governs the disposition of real property. Now, what it essentially says is that it requires, you know, the town to conduct a public hearing for the final approval of any sale, lease, or transfer of town-owned real property. And we'll talk in a minute about what real is versus personal property. But you have to have a public hearing, not a vote, but you need to provide transparency that you're looking to potentially dispose of real property. The exception being the $10,000 threshold. So the statute explicitly excludes property with a fair market value of $10,000 or less from the public hearing requirement. So, in theory, the Board of Selectmen could, if you were just following the state statutes, sell a piece of land, a parcel strip, if it were less than $10,000. However, in our charter, we've applied a lower threshold. We have 5,000 at present. So, and I assume that the selectmen ask us to look at this because they think that threshold is too low. But what we do have to keep in mind is that you at least need to public notice anything that exceeds 10,000. And so what I did discover as I was doing a little benchmark with some other towns, is there are some towns, even East Line as an example, they've just aligned their threshold with the state statute, saying $10,000 is if it's above $10,000, we need to have not only public notification, but we also have to take it to town meeting for a vote. What's interesting is the state statute, again, is just about the public notification. It doesn't specify, a threshold for which you need to take it to a vote at a town meeting. So in theory, and what again you'll see in some of the other towns, they specifically state in their charter things like a $50,000 threshold, like anything over $10,000 has to be noticed, but the Board of Selectmen and/or the Board of Finance have the authority to approve the sale of anything, let's say below $50,000. Over $50,000, it then needs to be voted on at a town meeting. So not to complicate matters, but there are some towns where they do differentiate. Some just go for the simplicity, 10,000 across the board. Others differentiate and apply a higher threshold to give their Board of Selectmen and/or Board of Finance more leeway. What I think is interesting about this, or maybe some more data we might want to grab, unless Marcia, you have a sense for this, but I know, again, from my time on the Board of Finance, what we would occasionally be asked to approve were the sale of these small strips of land, that were little pieces that maybe caught between two properties that, that the town technically owned but had no use for, and we think maybe one of the two landowners might be willing to take on that strip for a nominal price. So I think there were, sales that were of de minimis value, and so we probably were even under that 5,000. But there may be some that are between 5 and 10, and by increasing the threshold to 10 might make life easier for some in town hall. But so that's that piece. Although, and then having gone through this, my biggest concern, though, when reading our current charter, is the fact that I've only been talking about the disposition of real property. Maybe what I should do first here is differentiate real property versus personal property. So real property is, land and anything that's permanently attached to the land. So like a building, a school, or a town hall, or whatever. That's what the state statute references.
So a mobile home is considered real estate. They had changed the definition.
Oh, did they open a mobile? Okay,
So-
but hopefully
Really?
the town doesn't own too many mobile homes,
It
so
isn't.
hopefully,
It's real
we won't be but
They get the ones that go to the.
oh yeah, I guess you're right.
I
Wonder how they
Some of that,
define
yeah.
portable classrooms then.
Well, yeah. Although, it does say the definition for personal property is movable assets, which you think a mobile home would be, such as vehicles, machinery, furniture, equipment. So what's interesting, though, is in our charter, we specifically state the sale or disposition of real property and the sale or disposition of town-owned personal property in excess of $5,000. I didn't find any other charters that had a reference to personal property. They were all about real property. So I think, first and foremost, we've got an issue in our charter putting a $5,000 threshold in on personal property. And again, as a member of the Board of Finance for 10 years, I can tell you that's not, we're not necessarily abiding by that at the moment. Certainly, there are plenty of assets that are disposed of in town. Again, equipment, police
Probably
department.
vehicles.
Yeah,
The only thing
exactly.
that
Think
might
about all the
pop up.
highway department equipment. And I say, it's, and again, I think it's done, probably no concerns about how it's done, except for the charter company, but oftentimes, we'll trade, the highway department will trade in a vehicle or a truck for a new truck.
Police cars.
Police cars all the time, yeah. So we have to fix that at a minimum.
So here's a question then.
Yeah.
Do we split item number 4 into two parts, one for real property and one for personal, with possibly two different dollar limits.
So potentially some more research can be done here. What I was discovering though is, again, as far as the charter goes, everyone just focused on real property. And anything around personal property was really handled in purchasing policies or ordinances. It wasn't brought into the charter. So I think this is, again, to my earlier point about maybe a list of things for the selectmen to do after our, my preference would be to align with what I've seen in many other towns, which is just focus on the real property, leave the personal property out of the charter, but inform the selectmen that as part of their ordinance review and or procurement purchasing reviews, they should probably check that policy specifically. But yeah, that would be my recommendation. In terms of the threshold, do we go with 10? Do we go with 50? I mean, that we could debate that. But if you want to keep it real simple, I would suggest that we just change it from 5 to 10 and only have it reference real property, remove person.
I would,
10 still seems low to me, because even with roads, there's a lot of roads that have been taken over by property owners, which means now they can build where they couldn't build and expand. So some of that land is more valuable, or property that was across water, that somebody wanted a dock and they were willing to spend, $20,000 or $30,000 for some of that. So I don't see it as a problem, even if you had to notice it, and you had a provision, then it could be handled by the Selectmen or Board of Finance, that they could sell it afterwards, if we got anything that was up to that level. A lot of things may be just the 10, and it wouldn't be a problem, but I think going up a little bit further, where you don't have to go to a town meeting to discuss selling something or not selling something, would be, because nowadays, that's not a lot of money for anything, real estate related.
Yeah. And again, not to complicate this further, but I did find one town, it was actually Colchester, where they actually didn't use a dollar amount, they used a percentage. They said that the Board of Selectmen effectively have the right to transact on 2% of the budget, overall budget.
Wow.
Yeah, so that's a pretty healthy number. I mean, so we're like
very healthy number.
70 million, so that's like $140,000 for doing math right for Stonington. So that would probably be too high, but if you wanted to do
Because
70,000.
we still have the school in Pawcatuck, and you want to be careful with things like that.
Yeah.
You'd want to go to a town meeting if you want to get rid of a building like that.
Like the point that you made before, that the state statute says 10,000 just for notice.
For notice.
And so, is that sufficient, is the public notice sufficient? Do you have to put in a higher threshold, for, the disposition? Would you be comfortable with just the notice provision at the 10 grand if that didn't trigger a meeting?
Sorry, I'm not sure I fully followed.
So the state statute says you have to notice if it's
Over the 10, yeah.
over 10,000, right? So I was hearing Marcia's concern as, hey, we don't want to hamstring the town to have a town meeting at a low threshold.
Right.
But does the town doesn't mind doing the notice at that level?
Oh, higher than that level.
Right,
True.
yeah.
Some towns I know are doing 20,000, you could do 50,000.
Yeah.
And so you just have to notice it, but there would be a process, isn't that what you said, that the selectmen or the finance board could still sell it once they noticed the
Right.
public?
Correct, yeah.
Now, what is the
You have to notice.
What does the
and I-
notice do? Can someone object to it,
No.
or?
It's just for public comment.
Just
Just so someone can come and
And
express
it's
their
newspaper
opinion.
notice, by the way.
It's
Yeah.
not, oh, really?
Yeah.
The statute does reference
Yeah.
newspaper, yeah, which is unfortunate, but we can't really do anything about it. I think maybe, so I hear everything you're saying, Mark, and that was my gut as well, was, all right, the 10's probably still too low, let's give them something like 35, 50,000, something more, I mean, God, if Colchester is giving their board 140,000, to 10, but the only reason to maybe, in my mind, to keep it at 10 is it forces you to do the notice. My only worry with going to, let's say we go to 50,000, do we forget, to do the notice when there's a piece of property that's being disposed of for 20
Well,
years?
not if the charter has a provision that we provide notice as required by statute or something like that.
Could you do a combination where you would notice everything over 10, but you can sell under 1%, so that's like a 70,000, and you're not having to constantly go back in a charter and adjust to the CPI, it's like baked in.
Yep, that's the, right.
So that people have an idea if something's up, and the selectmen still don't have a ton of leeway, but they have more, 70 grand, whatever that would be,
Yeah, I mean,
So 1% of municipal budget,
something like that.
municipal expenditures, or, yeah.
yeah, so, right. Yeah, I see.
I'd be okay with that. And there's another, I can't find it right now, but I remember being on the Planning and Zoning Commission, and we had to take a vote about the disposition of municipal real property, that it was consistent with the POCD, with your plan of concept. So there's a secondary notice at a land use board in addition to, the general public. And that could be gone. I remember it, but I wouldn't bet my life on it right now.
John, just related to that point, so one other thing I should note here is there is in the state statutes something called the parkland caveat, which is even if the property value is 10,000 or less, the exception does not apply if the property is parkland, open space, or playground. In those cases, public hearing notification is required regardless of value. So again, we're having to notice in many instances. So we could just reiterate compliance with notification, but actually have approval, by like the Board of Selectmen and or Finance at a higher threshold. I mean, my gut feels like 1% would be maybe closer to 70,000. So, that probably is more than enough. But if we, I don't know. I could certainly talk to some folks down at Town Hall just to see what figure might feel more, if the board is, if you guys, the commission here is inclined to.
I don't recall that there was ever a lot anyway, even the time I was there.
Yeah.
With, I think it's sort of minimal.
Not many transactions coming up, is that?
Yeah, not that really that the
You're not disposing of a lot
process-
of property.
No. I mean,
Can you share your research?
Sure.
Okay, that'd be great.
Yep.
What I'll do, I'll put it on my list, do some comparative analysis, see what other communities are doing. But I think that Scott's approach is a pretty interesting approach.
Yeah, it's giving notice, so people can't say they didn't know, but it's giving a little bit of flexibility, right, to actually conduct the business of the town.
I think it makes a lot of sense. It threads a needle in a reasonable way, but I'm just voicing my opinion. I think the personal property aspect of it is maybe gets its own line or doesn't, because that's just too.
Oh, I think, sorry. I definitely, that's the thing I feel strongest about is that we have to remove the personal property piece because we're not following it.
We're not following it.
Yeah.
Reverse engineer the charter to
Yeah.
comply with the policies of the town. I've seen that, we've done that before.
But
I don't think
before,
it's intentional, we just never,
No, I get it.
never fully appreciate it.
but before we buy a $200,000 truck, there's a competitive bid, it's coming off this,
And we have
it's
all
going
that.
through, it's
Yeah.
going through the Board of Finance, it's going to the Board of Selectmen, so that there's a number of high-level, high-functioning boards that are looking at this and saying, this is in the best interest of the town before that asset gets disposed
See,
of.
the real estate side, you would probably, if the town, it wasn't specifically town property, but maybe there was a tax sale. So the town would put it out for a tax sale, someone may take the property, or if they didn't take the property, then the town has an option, they have to take it by foreclosure or write it off the books or whatever. And if there's a potential to earn money from it, they might take it by a tax sale, where they then could sell it.
Yeah.
So you might have that come up, but again, those things didn't come up all that much. And with mobile homes, it usually was someone abandons it, they leave, and then the town somehow winds up with it, and then they have to dispose of it, and it becomes more costly because you have to transport it, you have to make sure there's no contaminants in it, and it has to go through the transfer station, and it becomes more of a liability.
How do you,
I'm sorry.
Oh, no.
That's your point.
Well, I was going to actually wrap this one up. I was just going to propose that maybe, Steve, I share with you, the research I've got here.
Right.
I clean up a little bit, and then maybe we come back with a proposed language for the next meeting.
That was gonna be I was gonna ask you to do that.
Yeah. But, sorry, do you have something else you want to add?
Are you gonna draft the language? Or
Happy to do it with you.
Yeah, okay, let's,
I'll share the
yeah,
research, or
if
maybe
you
the
see
three
the
of us.
research, and then I'll do a little more. One of the questions I was having, we've never addressed this in this issue, so I've not delved into the charter. How do you deal with multi-year contracts in town?
We're,
And I'll tell you what the law is. but,
no,
see what you-
I remember distinctly you saying that boards of ed can't do a contract that exceeds their budgetary authority. But I mean,
They cannot go into anything that goes beyond the single year.
The single
So
year.
you need to have a legislative body. So the question I have is, does the Board of Selectmen have that authority? Do we have to go to a town meeting for the authority for
I
multi-year
would
contracts?
defer, I mean, I sat on the board of selectmen, I can't tell you, I don't know what we're doing in practice.
I'll ask Brian, because it's a major issue. A lot of communities don't take it seriously. You need, the Supreme Court is a very clear law that only the legislative body can commit the community to multi-year arrangements.
Meeting, a town meeting.
It could be the town meeting, could give it to the Board of Selectmen. They serve as a quasi-legislative, they have quasi-legislative authority. The question is, how much do you want to give them? So it's the same kind of issue. Is there a threshold? Is there something they can go up to, and then beyond that, they have to go to a town meeting? Like I was thinking, the thing that triggered it me, if you're buying a new bulldozer or a new truck or something like that, you have lease, there's lease language here for 5 years, lease options. And that's what got me thinking about it, because anything that goes beyond a year has to be approved, in my view.
So if we're not paying for it in cash, we need, if it's a 2-year, even if it's a 2-year term,
Yeah.
or 365 days plus 1 day,
Yeah.
we need the legislative body.
Yeah, you do, and you do have the option to delegate. So this 5-year thing could be a delegation of that authority that you have up to 5 years, but anything over 5 years goes to the town meeting, and then the Board of Selectmen has authority under 5 years, but generally, multi-year contracts have to be approved by a legislative body.
But if it's a
I
capital,
know-
aren't they capital leases where you actually own it, you just lease it, you just pay?
Whatever it is.
But it's still a multi-year.
It's a multi-year
agreement.
commitment.
Yeah, but
Because we're
it's-
binding
But it comes
future.
on our books, it's our books, it's not.
So bonding's like a completely different animal.
No, if you
because
bond, you're authorizing.
Bonding is
Yeah, yeah.
authorizing, right?
Then you're
Right.
authorizing, you know.
And so-
So you can authorize it, but you just can't, the first selectman doesn't have authority. The director of public works doesn't have authority. You need to have some legislative body give you authority.
We did approve
Or bond referendum.
vehicle leases in the 20,
It was a while back.
probably 2018
Yeah,
timeframe.
yeah.
Was the last time.
But we moved away from that.
Yes.
Yeah.
But I'm talking about something basic like software, which is not something. Servers, software, something like that. They could have multi-year.
Even the Board of Ed contracts, they contract
Right.
for multi-years.
They circumvent them all the time, and they do options. And option agreements are multi-year. Renewal agreements are multi-year. So if the Board of Ed wants to engage in that, look, there's nothing wrong with multi-year procurements, but you need to get authority to do it. So we're not saying the Board of Ed can't do it, but they need to have authority from somebody other than them to do it, some legislative body.
We've actually, I'm going to say, we've been blind to that, or I'm going to say just myself, I've been blind to that limitation. I had no idea it existed.
Yeah. I'll talk to Brian about it, see how he's coped with it.
But is this another one, I know we have a procurement or purchasing ordinance. Should this, again, be something that's handled there more appropriately than?
Yeah, I like to, sometimes I have definitions in a charter of what a contract is, and sometimes I have a definition of what a multi-year contract is. And we could leave it at that and leave it to a procurement ordinance to,
I know there is one, I don't know,
Yeah.
I can't
Yeah.
say that, but I know there is a.
but if you have a definition in the charter
Yeah.
that establishes the requirement, then you can do it, or you just just establish the requirement under the procurement section.
Yeah.
That's what I tend to do in my charters. You have the procurement function, adopt an ordinance, but the ordinance has to be consistent with state law so that multi-year contracts need to be addressed by the ordinance, so.
I know the revale, at one time the revale contracts, because you're going into 2 fiscal years, and you have to contract them for the whole process.
Right.
Yeah, no, we have, now that I think about it, yeah, there's that stuff. We've
Yeah.
done, like
But you
telecom stuff that we've contracted for multi-year,
And who's approved it?
board finance.
And then it went to the Board of Selectmen for approval also.
Yeah.
But as far as this limitation from and that's from a Supreme Court case in the state?
Multiple Supreme Court cases.
Multiple.
Yeah. It's pretty clear law.
Okay. So
I think, Brian, we wouldn't have a dispute on that one.
Wasn't it?
There we have clear Supreme Court law. And the Board of Finance is not the legislative body, unless there's a specific statute that
Yeah,
gives
no,
them that
no,
authority.
yeah,
Yes.
right. Right, the selection, I think actually they generally approve it first, or you vote, and then it's come, I think,
I think we do it after the Board of Finance, but I don't know. I can't be certain.
Well, they might do it before, because that gives the authority, and then they fund it or something.
Yeah, I
That's
think
how
that's
it's
what,
done.
yeah.
Well, who's
So-
actually signing? The person signing
Would be the
Select-
first selectman.
Fine.
Yeah,
It's the
yeah,
first
yeah,
selectman.
Yeah, but if you authorize, if the Board of Selectmen authorizes it, and they then fund it, it's fine.
Right.
You know, same thing true with the Board of Ed. But, well, the Board of Ed can only fund the 1 year, but they can commit now to multiple years, and everybody understands that that's going to be part of their contract for the next few years. It'll be in the lines of their budget, which they control, but they can't mandate it. The exceptions to the Board of Ed is obviously school superintendent. They have a statutory ability to hire a three-year contract, and they have teacher negotiation act provisions that could be multi-year. Although some of them have to go back to the council, but pensions have to go back to the legislative body. The Board of Ed has no authority on pensions. So, all right.
Okay.
Anybody, comments from anybody else on any other item?
Did we cover D under old business? I might have
We
missed
did
that.
not. We did not.
Addition, redundancies.
No.
Sorry,
Revised
gender
charter,
neutrality.
gender
Yes, we did
neutrality.
discuss that.
We did?
Didn't you bring it up, John, about authorizing?
No,
That's tonight we
that was
did.
the charter definitions, is what I read.
Oh, you're
made
right,
a
sorry.
motion on.
I thought I had authority already, but that's okay.
We're
Well,
bouncing
you know what,
around.
we'll
Yeah.
double down and say, I make a motion to instruct or have Attorney Bednick continue to make the charter gender neutral.
Second the motion.
Any discussion? All in favor?
Aye.
Please.
Any
Yeah,
opposed?
thank you.
Motion passes.
Yeah, I bought this, but I didn't make a copy of this one. I'll take one for you.
And so the only other thing is that I've got my name attached to a new business D.
Oh, sorry, John.
No, that's fine. It's all good. Quite honestly, I misunderstood the assignment.
Oh,
And I was just, what I did, I have a pass out here, not that it's worth anything, but it's kind of like, I had to start by getting my head around what boards and commissions and how everything functions and all of that stuff, because what I took on was trying to figure out, or try to do the legwork so we can decide which boards and commissions, if any, are going to be in the charter, and which ones we're just going to have off on ordinance. Right, and so so I misunderstood the assignment was for the redundancy part of it. So I was looking at, it's like, okay, well, what boards and commissions, what do we want? And so I started kind of bracketing a little bit, and you have fiduciaries in this town, and the number one fiduciary would be the Board of Finance, and that's very public. But there's another fiduciary on the retirement board, and that's not even, they're not conducting business even close to the way the ordinance that created it. So, and then beyond that, we got to the high-level boards, the Board of Ed, Board of Selectmen, and so I was like, let's get our head around how government functions, and then we'll make a stab at which ones we incorporate into the charter and which ones we just go with ordinance alone. And that got me down that rabbit hole of, hey, we're not doing anything close to the way this ordinance is, and this ordinance got some problems, and this one's citing a state statute that's wrong. So I ended up doing a bigger matrix of like, where are they, when was the statute created, when was it last modified, what's the statutory authority for these? And you know, how do you get seated? How do you get on there? You know, we've got one right now, the zoning citation officer is appointed by the first selectman, where most of the appointments are the board of selectmen. So, you know, you got going down these rabbit holes. But I think the fiduciaries and the high levels stay in the charter, but that's just one voice of 7.
What do we have in the charter right now?
It's a great question.
Oh, a whole
We
bunch.
have,
Is that right? See, I mean, what's the standard for having it in a charter instead of an ordinance? That would be the thing to consider. Because we don't want it to be like the Brazilian Constitution with 400 articles.
Or New Orleans or Louisiana, yeah, no, I agree. What I tried to do with charters, and I was looking at our draft, we started to do this in the last commission, but I'm not going to, what I'm gonna do is try to do an update, not including the stuff that I sent to David, because that was kind of approved tentatively by you guys, but I'm gonna try to start plotting things. One of the things that I do, both with departments and for boards and commissions, is try to move as much to the code of ordinances as possible. So that, so there are some boards that you would consider that would be mandated by the charter, kind of along the lines of what you're suggesting, whether the fiduciaries have important responsibilities. Board of Ed has to be in the charter. It's a statutory requirement. It needs to be in the charter. Board of Finance is a critical, in a town like Stonington is a critical board, usually planning and zoning. And the other question is who are elected, who are appointed. That's a secondary issue. And then you have a category that might be mandated by the charter, but created by ordinance. So these other ones would have the actual numbers, who's on it, how are they on it, what's their mandate, all that kind of stuff. You could still have elements of it that would be adopted by ordinance, but the actual creation of the commission is controlled by charter. I tend to put boards of ethics in charters because you don't want anybody to be able to take a board of ethics out. Some communities I would put, if there's an audit commission, an audit entity, you make that mandated so that a errant board of selectmen can't modify it.
We've never had an errant for selectmen.
Well, whatever, theoretically speaking, but whatever the case may be, I don't know the history. But but then you have like things like a recreation commission. You don't need, that does not have to be maybe even a parks commission. In some communities, parks commissions are sanctified. In New Haven, for example, if I ever tried to move the parks commission out of the charter to a code of ordinances, ghosts would come out of the Grove Street Cemetery and strangle them, and it would be a problem. So those are the two categories. And the third category is any other board or commission you may create by ordinance. That may be some that are already existing, but you have to decide, make some value judgments about what needs to be in the charter and what the category would be in the charter. So this exercise is a very useful.
and I'm not saying this is the definitive list.
No,
There's probably more boards and commissions that, so I'm just using the public documents as much as I can to get, this is the jumping off point. Now there's other things that, where do we go with them?
Let me just make one last point. The method of appointment should be governed by the charter. So who makes the appointments, how they are made, and what confirmation, if any, needs to be in the charter. And that would govern everything. So that if you create a board or commission by ordinance, it's not even mentioned in the charter, the appointment would be done in a manner that is required by the charter, unless there's a statute that requires other form of appointment or something like that. So that I would want to make sure that the constitutional rules on how you appoint department heads and how you appoint board and commission members is in the charter. So that's clear without any equivocation.
And this was very important to me because being in the position, there are certain key people that you really need in your town, and you don't want them disappearing because who's ever elected officials. And I think that was important to get them in as departments, which was finance, assessment, planning and zoning. And if the law changed and said, okay, we're not gonna use municipal assessors anymore, the law would take it out and it'd be a moot point. Same with, some other categories, but that was very difficult working, in an environment where, because you weren't listed as a department head, you were not included in any meetings, so you didn't know what was going on in planning and zoning in the town clerk's office. And for me, I needed to know I needed to know those departments because everything flowed down. And so by the time it comes down to you, you now have a legal issue because you would have known ahead of time that that was an issue for you, which was looked at differently. So I think just for continuity and making sure that you have people there that have the knowledge, that have the experience, and they're hired based upon their credentials, working for the town, and then when the selectmen come in, they can rely on those people and get advice from them as well. I think that's, to me, is good government. So that's my thought on those.
Mr. Chair, I have to excuse myself. I've gotta hit the road. I apologize.
Did it very softly, Scott.
Yeah.
Is the helicopter
Safe.
coming to pick you up?
I wish.
Yeah.
Safe ride.
Thank you very much.
So,
Safe
Should
travels.
say,
I mean, as far as this goes, yes, there are redundancies. I mean, I think I want to probably, listen to current first selectman and see, does he want to take on, some of these, keep them all, get rid of them, or because if they're ordinances, they're not in the charter, that's
Right.
not our charge.
Correct.
But we've got to know which of these groups we want to recommend keeping in the charter and not be.
and there's another reason why, and it's an important point, another reason why you want to clean up your ordinances. Sorry to be legalistic, I guess that's kind of my job. But there is a Supreme Court case, I think it's Norwalk versus Norwalk Board of Education, that stands for the proposition that if you are doing business with a municipality, you have an obligation to note the laws of the municipality, the charter, the ordinances, etc. And I really tried to impress upon my mayors and first selectmen who I deal with that if you have inconsistent charter and legal requirements in your ordinances, it undermines the advantage you have with that Supreme Court case, because then somebody can say, well, they don't know what they're doing. There's two different competing provisions, and and therefore I have nothing to worry about. And I'll tell you, I have used that case against a tax assessment company to knock down a $3 million claim to $750,000 because the prior administration and they did not comply with the charter in the city of New Haven. And it works very, very well, but you need to have that consistency. And what I've seen in a lot of charters, like on the issue of appointments, let's say the Board of Ed is in the charter and it lays out the appointments, but then you repeat it in the ordinances. You don't need to repeat it in the ordinances. The Board of Ed shall be comprised as set forth in section such and such of the charter. Every time you repeat something, you're going to make a mistake. It tends to lead to ambiguity, and you want to make sure that your ordinances are cleaned up so that we can address that. But the charter governs, and then everything falls from there. So everything flows from there.
The other thing was the authorities. I know you were going to look at definitions, and we have some authorities here that might not even be under the control of the town, right? That there would be quasi groups,
What could be?
like housing authority might not be necessarily the town.
It depends on how it's set up. Yeah, it depends how it's set
The
up.
housing
Could be.
authority was set up for Edith K. Richmond.
Yeah, but I don't know whether a quasi group should be in our charter,
That's a great question. That's a
That
great
was my-
question. Right, and then we went and created Housing Opportunities Commission, which was, another recent addition to, the boards and commissions. It just keeps going.
Yeah, if you created something pursuant to state statute, could it be the redevelopment agency, the housing authority, the parking authority, and they're really quasis, I don't see a need to have them in the charter at all.
Because right now we have 17.
Because you don't want to mandate them in the charter. There's
You have
17
17
authorities.
listed?
There are 17 boards and commissions in our charter.
Yeah.
And there's like 3 authorities, 3 or 4 authorities.
Yeah, 3 of them are authorities.
Yeah.
But was, I'll have to go back and look at my notes. Was this town or another town, we found out that something they were calling an authority wasn't really an authority. Maybe it wasn't here. I think it was Weston that just addressed this issue. Because some people call things agencies, some people call them authorities, and they're not necessarily. So you have to take a look at what each one of these things are. But my general review would be, you don't want to create in the charter something that statute allows you to create and to dissolve. And why have a provision in the charter that says you shall have a parking authority if you decide we don't need a parking authority? It shouldn't have to be a charter matter, in my view, but that's, I guess it's a local preference, but it doesn't make a lot of sense.
This is terrible, but my default position is, once you create a government entity, it is 20 times harder to remove it as it is to create it. And, you know, it's hard to get rid of something once it's established. So, I'll keep pushing on, I'll keep trying to do the data die, but I can tell you that I strongly encourage us to mandate review of the ordinances, because they're outdated. And they're not bad, they've just sat there for too long.
But to your point, though, one thing you can do to continue the debate when it goes to ordinances is to move some boards and commissions out of the category of being fully defined in the charter and move them to the code of ordinances. That way you can address the substantive issue of what the future of them should be.
So conceptually, should we decide, if we were to decide at the next meeting which we want in the charter, should we do a rapid review of those ordinances so that they match up, or is it just gonna be
We
charter?
have no authority of ordinances.
No, I know, but I'm just trying to, so
More
we're
like
gonna
do a review of the
basically,
ordinances so we know which ones are being affected.
so the ordinance, you're right.
What we can do is, here's what I'm going to promise. I just wrote a note to myself. I'm going to go through the charter. I'm going to mark up what we've done and mark up what's on our list, the to-do list. One of the things that I will do, I don't know if it's here. Yes, I have started annotating. I annotate charters as I go through them. And one of the things I might consider is, as we go through the board and commission section, and I have done this, is refer to the ordinance section in the annotation. And that's a way of doing kind of a review
Right.
of what the current status is. And that's not a hard thing to do. So as we're going through it, you give me the priorities, I can then annotate it and take a look at those sections. And that'll make it easier for Brian or whoever does it, gives it to a law student or however you want to do it, to go through and start cleaning up the ordinances at some point after this charter is adopted. But it certainly makes sense, because otherwise you're just shooting in the dark.
So we would leave as much, so if, let's just say it's 8 or 10 that remain in the charter, and then the other ones say we can have all these other ones, but the duties, the responsibilities, all those other things that's gonna get cleaned up in the charter.
You'll have one category of boards and commissions that will remain in the charter in their entirety. X number of members, there's a chairman, there's a this, and this is what they do. Then you'll have a category of these commissions shall be created by ordinance. Some of them may already be in the charter, and we're going to be recommending moving them to the code of ordinances.
Okay.
Right?
Okay.
And what we'll have to do, because you don't want to go naked in a year from November when you adopt this, and eliminate all those commissions, we will create a new chapter at the end, boards and commissions that are being transitioned, a transitions chapter to deal with them so they remain in full force and effect until the ordinances are adopted to conform to the charter requirement.
No,
So there's a methodology that I have for this. Same with the boards, the departments.
Right.
Depending on what we do with the departments. So I always create these transition chapters that will go away, they'll just fall away. Now, I have some communities, New Haven took 10 years to do theirs. We're finally done with it, we'll be done with it in the fall, 12 years actually, since we first adopted it. We've gone through another charter revision without changing the things that should have been changed. But other communities move quicker, and so that's what we would do. So everything stays in place until the ordinances are adopted to replace it. And in your case, the ordinances are revised, because you probably have ordinances dealing with some of these sections of the charter already. So we don't have to make those changes, but it would be very clear there'd be a roadmap in the charter to say how you do it.
Okay.
All right? Does that make sense?
No, and honestly, I was just thinking out loud as much as anything. I was just trying to wrap my head around the process, make sure I completely understood it, so. Because, I mean, I just don't want to still be, I just want to be able to make sure we get something out in writing, and we keep advancing the ball, because I just feel like, you know, we've got to get to the point, it's like, okay, these are the things, we're putting blinders on and doing this, and this.
And let's keep in mind, our deadline is in March. We have to get our charter, this document to the board.
Yeah, and that feels very close to me.
It's closer than you think.
It really feels close to me.
But we will take care of it, make sure. If we have to double up on some of our meeting months, we'll do that as well. But I will endeavor to make sure that you have in your hands kind of an annotated version of the charter that shows you what we're doing, what we're working on, and then that's a very good way to just keep up to what we need to get accomplished. And for me, it'll be good for me to go back into your charter, because we never had, the two members will tell you, we never had the mandate we had this time to actually look at the whole thing. I mean, it's, we were very constrained, so there are sections of charter I just didn't even remember existed, because we never looked at them.
Can you update this with those that are ordinance and in the charter, but they're in both? 'Cause some
I
of
can,
these- Some of
yeah,
these are
yeah.
not, some
Yeah.
of these are not in there, and some of them are.
Oh, no, and like I said, there's probably some I've overlooked, there's at least 8 that are still showing up on the town website that are dormant, they've not met in years. And I don't know if you can ever sunset, I don't know if it's ever possible to just, I mean, FOI requires us to retain the records, but if a board hasn't met in 10 years, does it show, should it show as a board?
Well, usually if the selectmen are appointing, they usually give them a time frame, like it's gonna run from here to here, and then it's
Right.
sunset, but if we don't do that.
No, this is a work in progress, and like I said, I misunderstood. I think we need to know, you know, let me just make sure I've got, feel confident that what we're here, and then we can start flagging. We'll flag what's in there, and then in our next meeting, we'll decide which ones are gonna stay, if it's mature and ripe at that point.
My suggestion is that you're probably not going to decide that the next meeting, with all due respect.
Okay.
What you can do is come up with a list, because this is where you're starting to carve. You're trying to, you may be hitting muscle, so you want to make sure that, you know what I'm saying?
Yep.
We want to make sure that we are talking to the right people and making decisions. So I think having the list is a really good thing, and I'm an advocate, so
Yeah.
I'm not speaking as
Okay.
somebody who's a
No.
naysayer
No,
on this.
no.
I'm a strong advocate of moving things.
This one's going to be thorny for a lot of reasons too, and even how do we word this one in terms of the vote? Like what if someone, you know, has an issue with, you know, they're comfortable with 19 of the 20 proposed changes.
I know.
But yeah, I mean, it's back to like the broader question we were talking about earlier.
You don't want to have 100 questions.
Yeah, but yeah, we won't be able to separate this into an additional
It's gonna be hard.
19 questions,
It's
right?
gonna be hard.
How are we gonna phrase this change?
Well, you also, you mentioned before that with some of these, that if we take it out of the charter, there'd be provisions in our charter that it wouldn't end until the ordinance was done. Or some kind of.
That's
wording
correct.
to
Yeah,
that
the public
effect.
will
So-
have input. I mean, so the first decision is, do you move things to the Code of Ordinances? It will still be in the charter, so the status quo remains until an ordinance is adopted. And those people who are concerned about what you're gonna do to the
Shellfish
Recreation
Commission or
Commission,
whatever,
the
yeah,
Shellfish
yeah,
Commission,
yeah.
whatever it may be, will have their say in the adoption of that ordinance. And otherwise, it stays exactly the way it is. So if they want to kill it, in the ordinances, that charter provision
How do you
remains as if it
explain
was
that,
never
you know?
moved.
So I will keep,
Well, we'll explain the explanatory text.
yeah, I will keep working on this draft, and I will color code the ones that are currently listed in the charter for next meeting.
If you can get me, if you do it soon, get it over
Yep.
to us,
Right.
so I can maybe start,
Well, it's a lot of work, because I've done as much public data mining as I can, and I really need to kind of, you know, the easy stuff is
Let's sit
here.
tight.
The
Let's sit
last
tight. I'll do what I have to
5%.
do. We'll-
No, no, but
I'll
I'll
bring it
keep
up to date after
working
the
on
next
it.
meeting. Don't worry about it.
I'll keep working on it.
Oh, John, I like this.
What?
I mean, you said you misunderstood. I think this is great.
Well, because we can't, I mean,
Right.
we, you know, this is a heavy lift.
Yeah.
This is a structural
Oh, this is a big
change
deal.
Great stuff.
Yes.
that's huge, and I think it's gonna take a good explanation to the town why we pulled it out of the charter and we put it over here where we can modify it without being, you
Well, I
know.
think it gives the public more input on the ordinance than it would on the charter once it's set, you know, because they can change the
Yeah,
ordinance.
yeah.
you know.
Right, because you can, theoretically, if we make these change, in terms of petitioning, if it's 200 signatures, you can bring an ordinance a lot easier
Yeah,
to,
yeah.
than you can a charter revision.
Yep.
Because if you don't like what's in the charter, then all of a sudden you gotta go to the Board of Selectmen and say, we want you to have a charter revision commission, and if the Board of Selectmen says no, there's nothing you can say about it.
Well, you can petition, but that's
Yes.
not easy.
Petition,
That's
right.
not easy. But
Right,
in all my years, I've never dealt with a petition commission. I've never, ever. I mean, I've done almost 40 of these things. I've never dealt with a petition commission. But there are safeguards, and that's what the public needs to understand, is that even if we do it, they're still there until the public approves the ordinance at a town meeting, in all likelihood. Yeah.
So consider this a draft, and I will keep working on it until I feel that it's not verified, but more than just a draft. But, you know, there's hours in just getting this put together, too. You know, going
what I
back
do for a living, man.
and trying to find, you know, because some of them, there's no statutory authority. But, you know, the board, you can create a full-time board or commission, but, you know, it's not like the statutes say there shall be an inland wetlands or a planning and zoning.
Are there any dormant commissions that are in the charter?
That's going to be a great question. I don't know. I didn't think about
I
that.
think there are, yeah.
That's-
I remember
yeah.
circling one or two, I'm like, I've
Because-
never even heard of this.
Well, because, let me see if I have the dormants here. So the dormants are Affordable Housing Advisory, Field Oversight, Athletic Task Force, Plastic Bag, Ad Hoc,
You know, a task force type things.
Step Ad Hoc, Building Replacement. So some of them we created boards or commissions just for a specific task. They did the task, but they still show, but we still have to route
Yeah,
people to
absolutely.
the minutes
Yeah.
for FOI compliance. So,
Abe Ripkoff used to say that we are a nation of faddists. These are fad commissions. These are all commissions that came up because of a certain thing that we were doing. It's one of my favorite Ripkoff quotes.
Okay.
All right.
I don't have any others.
Any other comments from anyone?
make a
Motion
motion
to
to
adjourn.
adjourn.
Second.
All those in favor?
Aye.
Scott, thank you for attending.
Thank you.
All right.
Well done. Thanks. Bye-bye.
Thank you, guys.
Good discussion.